So last time we began discussing reviewability, I mentioned section 701. I didn't have a slide on it. I should have. So I'll reconcile that, or I'll fix that today. So our principal question in reviewability is going to be, is something reviewable at all in the first place? Or at least that's the first question we're going to ask, right? And so section 701 starts with this chapter applies, and this chapter is the 700s of the APA, which is all of the stuff on judicial review. And so it says this chapter, meaning the chapter on judicial review, applies according to the provisions thereof, except to the extent that one of these two things is true. Either statutes preclude judicial review, and the statutes there means the Organic Act, or agency action is committed to agency discretion by law. So two different ways you can just never get review. If the Organic Act says or in some way precludes that review, or if agency action is committed to discretion by law. And so our two cases from last time were about the first part of this, when statutes preclude judicial review. And we saw that they can do so either expressly or impliedly. So we had one case on express and one case on implied. And then Overton Park and Webster v. Doe and Lincoln v. Vigil are going to be about this second one, when agency action is committed to agency discretion by law, and so there is no judicial review at all. And the puzzle here is that 701 says you don't get judicial review if the agency action is committed to agency discretion. But 706 says one of the reasons a court can set aside agency action as unlawful if it is an abuse of discretion. So how can something be an abuse of discretion and therefore set aside by a court as unlawful if it's committed to agency discretion and therefore a court can't review it in the first place? And so our puzzle for these three cases is going to be, how do we reconcile these two provisions? And so our first case on that is going to be Overton Park, which we have seen before, right? This is the case about the Secretary of Transportation having to approve highway funding to construct an interstate highway, but can't do so if the highway goes through a public park unless there is no feasible or prudent alternative. And I'm going to take down the slides unless someone would like me to hold them up for a minute. Okay. So for this, we've got Mr. Bowie, or I know you've told me in the past if it's Bowie or Bowie, but I don't remember, and I'm sorry about that.
It is Bowie, yes.
Okay. Ms. Cerulli, Ms. Emery, and Mr. Ferrier, how are you guys doing? Are you around? Are you ready?
I'm here. I'm doing good.
Good.
Hello, doing well.
Awesome.
Hi, I'm doing well.
Good. So, so that's what's going on here. So what's the government argument here that this shouldn't be reviewed?
The government's argument is essentially that it should be left up to administrative discretion, and that the requirement that there be nothing else prudent allows the secretary to exercise discretion in weighing factors, and that he can determine what factors are necessary to be weighed and making a determination.
So why is that? Why do they think this is the kind of thing that really should be left to the secretary? Like, what is the argument that this should be something, you know, within the secretary's discretion? I mean, because like if you imagine you're writing a brief to the court as the government lawyer here, like your argument is going to go something like, this is a decision that is committed to the agency discretion by law. And we know that because what?
I'm sorry, Professor. I know that you've stated it a couple different ways, but will you restate the question?
Sure. And maybe this is more of a brainstorming question than, because the court doesn't really go into a lot of detail on this, right? But like, if you're arguing for the government, what is your argument that this is or should be a decision that is committed to agency discretion by law, right? Like, if you're writing your brief, you say, this is the kind of decision that Congress had in mind when they said a decision that is committed to agency discretion by law because law.
Is it just because the secretary is in the best position to exercise discretion, has the most knowledge about what should and shouldn't be considered in terms of what is or isn't better about constructing a way through a parkland?
Yeah, so that's going to be one very strong argument, right? Like, this is the kind of thing where the agency has the best information, right? It has, well, I mean, where does it have information from, right? Like, it has information from the city council, but like, it's not on the ground in was it Memphis or Nashville? I forget. It's not like the local city council, so it doesn't have that kind of information, but like, what kind of information does it have? Is it a better position than the court to balance?
I guess since this is the kind of decision where that they've made repeatedly in the past, and this is something that's under their purview before, so that's probably an issue they've looked at and weighed the exact same factors in other situations and other environments, so they're in a better position to know how it stacks up.
So they have a lot of expertise, right? But it's also, isn't like, to what degree is this a political decision as opposed to like a cost benefit analysis type decision?
I mean, I would argue that it's both, but possibly more of a political decision, since at the time of the decision and still now, there is so much just controversy over environmental regulations and things.
Yeah, it's the kind of decision where you're balancing political factors and, local on the ground factors, like what would be the harm from routing this outside of the park, and environmental factors. And like, in this case, as we know, there were factors that related to, race relations in the city and kind of the enforcement of civil rights laws, right? And so it's a whole bunch of different things that we're balancing that are kind of different kinds. And so it's not like the kind of decision where you can look at the scientific evidence and kind of, if 10 people who were all trained and understood the science looked at the evidence, like, they might come to different answers, but they would come to like answers that were sort of clustered around some kind of right answer, right? Like, if you asked 10 scientists the right level of, emissions of mercury from a power plant, right? You're not going to get like 5 and 5 billion. You're going to get like a fairly small range of numbers, right? Because it's like clear that you're trying to do one thing. You're trying to come up with the healthy answer, right? Or the answer that best balances health and the costs of producing the energy or producing whatever they make at the factory, right? As opposed to this, where you're trying to balance like race relations and political concerns and environmental concerns and like a whole bunch of different types of things. And so that
Professor?
sounds, yeah, go ahead.
Sorry, I just have a quick question. In this argument, why did the government focus so much on prudent as opposed to feasible? Was that just like a random choice? I just don't understand the distinction. Like the government was like, underneath this prudent aspect of the act, this is where we're doing the balancing of these competing interests. And I'm just curious as to why they chose prudent and how that differs from feasible. I just don't understand. Was it just a random choice between the two? It seems kind of strange to me, and I just wanted to ask your opinion on that.
No, that's a really good question, right? That's actually that's a good point that I should bring out, and I will add that to things to talk about next time, right? But like, so the statute says the secretary is supposed to consider whether the alternative is feasible and prudent, right? So like, if you're the government lawyer, what's your argument based on that? Mr. Bowie, Ms. Hurley, Ms. Emery, Mr. Ferrier, how do you unpack that definition? What do you say about that?
Well, I was just gonna say it kind of goes off of that. They didn't really go into it too much in the case, but it seems like part of the argument might be based on their larger argument that the secretary has discretion to make the specific decision, so that discretion should be moved over to section 701. So that might weigh in where he has to make decisions as to what is prudent, and that gives him a greater amount of discretion when it comes to reviewability. But I'm not sure about that.
Do you think the secretary has more discretion if the statute said feasible or if it said prudent?
I would say more.
For which one?
If it said prudent.
Yeah, because like feasible says, is there a way to do it that doesn't go through the park, right? And that sounds like something that the court can reasonably well figure out. Like that sounds like, there would be an expert report that said, well, if we route it around the park, we'll have to tear down these 300 houses, but it's doable, right? That sounds like this kind of thing that a court can say, yeah, that seems feasible. But what does prudent mean?
It's much more of a judgment call.
Yeah, it seems like it's more about, not only is it possible, which seems like what feasible is about, but is it a good idea? Prudent seems like, and let me just look up real quick what prudent means according to the dictionary, right? But it's like, to me, it's like, is it wise to do it, right? So Merriam-Webster says, characterized by, arising from, or showing prudence, such as marked by wisdom or judiciousness, shrewd in the management of practical affairs, prudence, the ability to govern and discipline oneself by the use of reasons, shrewdness, skill and good judgment. And so like, to me, prudent means, is it a good idea? Does it represent good judgment? Is it the wise decision? Is it the best balance of all of these things? Whereas feasible is much more, is it just possible and practical, right? And so if the government says, if I'm the government, my argument would be, the statute says we have to decide both that it's feasible and that it's prudent. And yes, a court might be well equipped to decide if it's feasible, but a court is not equipped to review the decision whether it's prudent, whether it's wise, whether it's a good idea balancing all of these different things. Like that seems like a fundamentally discretionary decision, right? Does that help? Did that make sense? So I think that's the argument, and it sounds like a reasonably persuasive one, right? So why doesn't the court buy it? Why is this not carved out as agency action that is committed to agency discretion by law?
So first they looked at the threshold question in section 701 of the APA, which says that it's subject to judicial review except where there is a statutory prohibition on review or where agency action is committed to agency discretion by law. So basically, according to like the legislative history of the APA, it doesn't fall within the exception because it's a very narrow exception that only applies when statutes are drawn so broad that there's no law to apply.
Yeah, that's what the court says, right, on this paragraph in the middle of 962, that this committed to agency discretion by law under 701 is a very narrow exception that applies in those broad instances, in those rare instances rather, where statutes are drawn in such broad terms that there's basically no law to apply. And what's the law to apply here? Like, why is there sufficient law here for the court to evaluate?
Yeah, because the existence of statutes that talk about the value of preserving parkland indicates that Congress wanted the secretary to consider that when making these decisions. So if the secretary ignored these considerations, they would just apply that and say that you should have considered these dimensions when exercising your discretion.
So we've got a couple of things we could do to say this was an illegal decision. One is if the secretary didn't consider the right things, right? Like there's a law saying the secretary is supposed to do, supposed to make a decision based on X, Y, and Z. What is the secretary supposed to consider? What is the direction of the law? When I say that, what does the law direct, I guess, makes more sense.
The court says if the statutes are to have any meaning, the secretary cannot approve the destruction of parkland unless he finds that alternate routes present unique problems. So it sounds like almost a presumption that this is supposed to be given deference unless there's unusual circumstances, and that Congress making a law directly talking about preserving parkland indicates that.
So it's almost like if we had two different ways we could write this statute. One that said, the secretary will decide whether to approve the route considering the following 5 things, right? Whether it goes through a park, whether it's possible and prudent to not go through the park, et cetera, right? What if the statute said the secretary will make the decision? That's different than what we have here. What we have here is the secretary may not approve it if it goes through the park unless it satisfies this exception, right? And so it wasn't a law like conveying discretion. It was a law saying, no, don't do this unless there is some strong reason to, right? But isn't that still like a balancing test with a bunch of factors? Like, isn't that still, you can have discretion about whether something meets an exception, right?
Yes, but I think when it comes to the committed to agency discretion section, because the court has said that that's really narrow, it needs to be something that isn't quite so do not do this unless. It needs to be something like the other alternative that you presented. I can't really conceptualize exactly what they're looking for with that. That was a little bit broad, but I would guess that what you said in the alternative would be more along the lines of what they're looking for that particular piece of the test.
Yeah, I mean, like, Congress here clearly wasn't just saying to the secretary, make some reasonable decisions, right? Congress had a preference. And what was that preference?
Protect parkland unless alternate routes create unique problems.
Yeah, right. This idea that parks are always going to be really tempting to people who are building highways because they're always going to be the cheapest option. But Congress didn't want to spend a bunch of federal money only to destroy parks, right? And so Congress basically said, we don't intend all of these factors that you're balancing to be equally weighed. We intend for parks not to be used unless there is really no other option. Now, I mean, it's hard to know if that was really Congress's intent. Like, these are fundamentally political questions, and presumably the Secretary of Transportation is relatively well equipped to know what the political factors influencing Congress and influencing the local community are, but that's the court's conclusion here. one last little question on this case before we'll turn to Webster v. Doe. The notes raise an interesting counterfactual here, which is if the court had issued this decision at the beginning of the period where they were considering this project, like in the 50s instead of 1971, what would the effect of the decision have been for highway construction?
I think in the 50s, there was less of a concentration on environmental protection. So it would have given highway construction a lot more leeway when creating all the different routes.
So the court would have been less likely to protect the parks?
In my opinion, yes.
Yeah, I think that's probably right. What if they had done the same thing, though? What if they had come out with the same opinion as they did here?
I think our highway system today would look a lot different.
Definitely, right? Why?
Well, if this attitude, if we want to call it that, had been, statutorily invoked back then, I think that there would have been a lot less highway construction that went through parks in the 50s.
It would have been much easier for local opponents to challenge decisions about where to build highways, right? Like the interstate highway system was sort of really began being constructed sort of at scale in the 50s. And if the court had said in 1956, yes, courts can review a decision about where to route a highway, then that would have tied up a lot of highways in court for decades, right? As opposed to a lot of highways got built in the 50s and 60s before the court said this in 1971. And so this is an example of where, by saying, yes, there's judicial review, potentially it would have had a big effect on how something the government was doing could get done. Because by interpreting committed to agency discretion by law very narrowly, the court is going to further this idea that anything an agency does, there's probably some way to get review, right? And that's going to make it much easier if you're an opponent of something the government is doing to try to tie it up so that they can't get it done. And so that's the upshot of this opinion, is that the court defines this exception for committed to agency discretion by law very narrowly. It says basically it only applies when there's no law that you can really apply. The next two cases, though, are going to find it satisfied. And so we'll have to ask, are those cases where there's no law to apply, or are they somehow exceptions to this rule, or has the court kind of ignored this rule since 1971? So questions about that before we turn to Webster versus Doe? Okay, so Webster versus Doe is a case about what is sometimes called the political question doctrine, which is a set of cases where the subject matter of the lawsuit is left to the other branches of government and not considered appropriate for the courts to resolve, even if you have standing and ripeness and all of the other Article 3 criteria to have a case to be heard in court. And so they tend to fall into a few categories. One is where the courts conclude that issues have been specifically entrusted to Congress or the executive branch, or the most recent category was the Supreme Court a few years ago said political gerrymandering cases fall into this bucket as well. And we might think of those as cases where the decision has been entrusted to the states. And there's a couple of ways to think about political question cases. One is where you have a defendant's action that is subject to some kind of law. There is some legal constraint or there is some legal requirement constraining how the person can act, but the court says that legal constraint is not one that is enforceable in court. And the other kind of category is one where the defendant's action is one where there is no legal constraint, where it's wholly within that entity's discretion. And so these cases are basically that second one. This idea is that these are situations where Congress gave the executive branch so much latitude that courts can't review what they did because what they do is just fundamentally legal regardless of what they do because it's entirely within their discretion. So what's going on in Webster v. Doe? What's the factual background here? What's the agency and the statute and stuff?
So the agency is the Central Intelligence Agency, and the statute is Section 102C of the National Securities Act of 1947.
And what does that section do?
It gives the discretion of the director of the Central Intelligence has discretion to terminate an employee if they see fit.
Yeah, it says
If
the
they,
director. Go ahead.
Oh, I was just going to say if they determine them as a security threat.
Yeah, the director of Central Intelligence may, in his discretion, terminate the employment of any officer or employee of the agency whenever he shall deem such termination necessary or advisable in the interests of the United States. And here, the director fired an officer for being gay, and the officer sued, as one does. What's the claim brought by the plaintiff here?
The claim is that the decision to terminate him was arbitrary and capricious, and that it violated a number of his constitutional rights.
So we've got two different categories of claims, right? We've got APA claims. This was arbitrary and capricious. This was an abuse of discretion. This failed to follow proper procedures. These are all 706 type claims, right? And then we've got some constitutional law claims. This violates the First Amendment, the Fourth Amendment, the Fifth Amendment, the Ninth Amendment. Name an amendment, it probably does, right? And so the court begins by laying out this distinction between these two subcategories under 701 of actions that can't be reviewed, right? What's the distinction between these two as this court explains it?
I'm sorry, could you say that again? I couldn't hear you.
Sure. So the court's legal analysis begins by discussing this dichotomy in the Administrative Procedure Act under 701A between statutes precluding judicial review and agency actions that are committed to agency discretion by law, right? That's 701A1 and 701A2. So what's the difference between those two things, according to the court? Like, how does the court describe and explain these two provisions?
In the first instance, the former, they say, has to be expressly forbidden by a statute, whereas the latter, they use the Overton Park standard of no law to apply, and then the Cheney standard in conjunction with that, where there's no meaningful standard against which to judge the agency's exercise of discretion.
So 701A then is about whether Congress expressed an intent to prohibit judicial review. So in the statute itself, while 701A2 is about what?
Whether it implicitly intended to?
I guess, right? Like, it's not super clear, right? 701A1 is concerned with whether Congress expressed an intent to prohibit judicial review. But 701A2 is still kind of about Congress's intent, right? Because like in the last case, it was about Congress intending the secretary to decline to let them put a highway through the park, right? Congress gave a policy directive to the Secretary of Transportation. So 701A2 is kind of about implicit statutory limits, even though, as we saw last time, 701A1 can also be implicit, right? So not super clear what the point of A2 is, right? They say toward the top of 972, we noted that under section 701A2, even when Congress has not affirmatively precluded judicial oversight, review is not to be had if the statute is drawn so a court would have no meaningful standard against which to judge the agency's exercise of discretion. I guess another way of saying that is it's hard to do something arbitrary and capricious if the statute doesn't give you any meaningful distinction, right? Or any meaningful standard. Which one is this case? Is this A1 or A2?
They look to A2. So the court specifically looks at the language within 102C, especially at the word shall deem, which indicates that they had the intent of giving the discretion to the CIA director.
Yeah, like the court says, and this is that last sentence right before Roman numeral 3 on 972. We thus find that the language and structure of section 102C indicate that Congress meant to commit individual employee discharges to the director's discretion, and that section 701A2 accordingly precludes judicial review of these decisions under the APA. So they expressly say, this is 701A2. This is agency action is committed to agency discretion by law. And in the same sentence, they say Congress meant to commit this to the agency's discretion. And therefore, Congress effectively precluded review, right? So it really seems like this one sentence kind of would fit under A1 or A2. But the court cites A2. So one takeaway from this case then is it's really confusing now what the difference between A1 and A2 is, right? Because the court seems to be saying they mean the same thing. Okay, couple more questions about this, and then we'll switch to our second panel for the second half of this case and then the next case. So Overton Park was sort of about the same argument, but it failed there because the statute said the secretary can only approve a routing through a park if there's no feasible and prudent alternative. Under this statute, when can the director fire an employee?
When he deems it necessary.
Necessary for what?
For the interests of the United States.
Yeah. So how is that the kind of thing where there's no law to apply? Like, it seems like the statute here does create a constraint that it has to be about national security, right? So
Well,
like,
I feel
if,
like
go ahead, sorry.
I feel like the CIA would have the most knowledge on what would be considered a threat to the United States.
Mhm.
So they're the expert in this scenario.
So if the CIA director wrote a letter to an employee saying, you know, there is absolutely no national security problem with your continued employment, but I just don't like looking at you every day, and therefore you're fired. Would that violate the statute?
It seems like it, since he's kind of being express about firing someone based on conditions that aren't granted as part of his discretion on the statute.
I mean, even though the court says like, it's not just that it must actually further national security, it's the director has to deem that it's in the interest of the United States, which implies even more discretion, right? But you can imagine a scenario where the secretary or the director of the agency doesn't even purport to deem that it's national security, right? Just like, you know, I don't like you, you know, I find you annoying, you know, the fact that you just bought a Porsche makes me feel bad, right? Like, therefore you're fired. Like, that's not even trying to say it's national security. That's just like petty personal stuff, right? Or like you went to, you know, I went to Harvard and you went to Yale, right? Like, therefore I don't like you, right? That's
Professor, I have a
mostly
quick
it.
question.
Yeah.
In the statute, does it have to list the reason why he believes it's national security? Because this reminds me of at-will employment, where there's technically federal regulations, like you can't fire somebody for being a woman or being black, but you could make up any excuse that is like hide the reason. Would the director have to say like, this person is gay, ipso facto, this is why it's national security?
I mean, I think after this opinion, no, I think after this opinion, the court is saying it's not even reviewable, right? Except for the constitutional claims.
My understanding of the distinction between this and Overton Park was that this kind of felt like more of an affirmative grant of power rather than the you shall not unless X in Overton Park. Although in practice it might be very similar to the way that the director has to go about things in Overton Park, or the secretary rather. The way it's written seems more of an affirmative granting of power.
Yeah, maybe that's the best way to think about it, right? Because like Overton Park says, you know, you can improve it, but only if X, Y, and Z. And here it's sort of, you can fire people and you just have to deem that it's national security, but it's still sort of like, at least as written, it's a constraint. Like you can't fire someone if you don't deem it national security, right? But this court is unwilling to examine that type of decision by the agency director, because why?
It seems like there might not be any competing interests in this case, like there were in Overton Park, where you had the competing interest of wanting to preserve parkland that they imposed as a set of considerations to kind of mitigate their ability to just go and build highways wherever, whereas there isn't really something here that they talk about expressly that they want the CIA to consider in opposition to national security interests, or I guess the interests of the United States.
Yeah, maybe that's a good way to put it, right? That like, it's sort of the, as long as you have any national security interest, you're okay firing this person. And it's not really something where the court would be well equipped to evaluate whether these other competing interests, like dislike of gay people, would counteract that, I guess. I mean, this really seems like the kind of case where there's something going on below the sort of direct statutory analysis, right? Which is that like national security is the kind of area where courts feel sort of at their lowest level of competence to evaluate the decision. Because the only real way you can probably figure out if this was about national security or not is by like cross-examining the CIA director. And that would present all kinds of like classified national security type concerns that are not things the court really likes to get into, right? Okay, thank you, Mr. Bowie, Ms. Cerulli, Ms. Emery, and Mr. Ferrier. So let's switch over to Mr. Cox, Ms. Ezell, Mr. Hall, and Mr. Tom Kunis. How are you guys doing?
Good. Fantastic.
Awesome. why isn't this just like a 701A claim, that this is A1, sorry, claim, where if the statute says it's in the director's discretion and it doesn't lay out any legal test, why isn't this something where the statute precludes judicial review?
I may not be understanding the question correctly, but like you pointed out earlier, it is kind of hard to see why they went for 7A2, other than the statute itself did not directly say that a court cannot review this like in an explicit sense. So that's why they kind of moved into the second part to make sure that the same idea took place, would be my guess.
Yeah, I mean, we don't have any kind of real statutory prohibition, right? And so we don't have any express preclusion like we did in Johnson v. Robeson, right? Could we say something like Block versus Community Nutrition Institute, where it's like implicit in the structure of the statute that there's no judicial review?
I think so, just because of how powerful I think he said it exudes deference to the director, almost like it is implied in the way that he says shall deem such termination, and deem is such an opinion, that almost by itself is calling the authority the director and not the courts.
Mm-hmm. What do the others think? Mr. Hall, Ms. Ezel, Mr. Tomkunis, any thoughts?
I largely agree with Cam, but I can see where they rely on the agency action is committed to agency discretion by law, because of the he shall deem language in the statute. There's really no test for the court, the reviewing court, to apply to deem it an abuse of discretion outside of like what Scalia talks about in the dissent, maybe.
Mm-hmm. This is sort of the problem with the no law to apply test, right? Like it seems to look to the same kinds of things that the statute looks to with implied preclusion under 701A1. And so taking this opinion as a, piece of doctrinal analysis of section 701, it's kind of hard to come up with something coherent coming out of it, right? Which suggests that it probably really is kind of a, it's a case that combines national security with like left-wing social politics in the 80s, which is probably the kind of the area where the court feels least willing to wade in. And so the court kind of comes up with an excuse to avoid deciding it. What about the constitutional claims, though? They're not necessarily precluded. Why?
They said that unless it is that Congress it has to be clear that Congress intended those claims to not be addressed, and it doesn't seem like that did happen here. So they think it went too far to say that this was a complete in 102C to say no, the judicial element can't come in regards to the constitutional claims.
Mm-hmm. I mean, so the APA section 701 says you don't have to hear a case that is committed to agency discretion. What is the scope of that exception, though? Like, is that you don't have to hear any kind of case at all, or what does it apply to?
It seems like from this that, like what Cam just said, it only applies to like 701A or 701A1 in A2, and then, but unless it like expressly excludes constitutional questions, then like I think after that it only hold on. What I'm trying to say is that it doesn't exclude constitutional questions. So like the scope of it doesn't extend to that unless, like Cam said, it has to be clear. If that makes sense.
Mhm.
I'm like trying to go through it in my brain as I'm like trying to answer your question.
Yeah, let me pull up the text, right? Because I'm sort of having the same issue, right? So 701 says its scope is this chapter, right? Meaning the APA's review provisions in the 700s, right? And so 701 would apply, or would not. 701 says 702, 703, 706, et cetera, don't apply when agency action is committed to agency discretion by law, right? And so like 702 creates a right of review if you're aggrieved by the agency action. 703 says you can, bring any kind of claim you want. 704 says some stuff about when it's reviewable. And then 706 says the reasons that a court can hold the action unlawful. Is a constitutional claim a claim that would be under 706?
I don't know if this directly answers, but this just came to me, like even going back to 701, and I think this will answer the 706 question. Like the first part, unless the statute says it, then Congress can't regulate that. And at least in my understanding, the courts are the arbiters of constitutional, like I'm whatever that is, Marshall, way back when in 1700, that they are the ones who speak about the Constitution.
Yeah.
So the second one wouldn't encompass that. The agency therefore could never have that first right of discretion in constitutional matters unless Congress were to give them that right. So only one could apply to that, two couldn't. So therefore the constitutional claims stay, if that makes sense.
Yeah, maybe. But like if my argument is that something an agency did is unconstitutional, is that an argument that I'm bringing under 706? Or am I seeking to apply 706, I guess, is a better way to say it.
I'd say it seems like it. Yeah, that's where it would come in.
Yeah, right. Like 706(2) says that the agency or that the court can hold unlawful and set aside the agency action if it's otherwise not in accordance with law. And I think one of the other 5 listed here is, violates constitutional rights, right? So 706 lists some remedies that you can get for an unlawful agency action. And one of the ways the agency action can be unlawful is if it violates the Constitution, right? But 701 says that 706 doesn't even apply if it's committed to agency discretion by law, right? So, like, that's the argument that this should block even constitutional claims, right? So why doesn't the court do that? And this is kind of what you were getting at before, I think.
The court says that it like requires that heightened showing in part to avoid a serious constitutional question that would arise if a federal statute were construed to deny any judicial forum for a colorable constitutional claim.
Yeah, so they kind of just interpret it according to the constitutional avoidance doctrine again, right? This like, the statute seems to block this, but we don't like that idea because that would be a hard constitutional problem. And therefore we're going to ignore it, right? Or we're going to construe it not to cover this. So on the statutory claim, you can bring a claim under 702 that gets you a remedy under 706, but it's blocked because 701, right? What's the source of the cause of action of the constitutional claim, though? And this is kind of getting into federal courts territory and not really this course. And so we'll move on in a moment, but it's a weird side puzzle.
Is it due process?
So it seems like it has to be, right? It has to be like from the Constitution itself, from the due process clause in the Fifth Amendment and whatever the First Amendment claim was and whatever the Fourth Amendment claim was, right? Does anybody know what the cause of action against a state for violating constitutional rights is, where it comes from?
Is it the 11th Amendment?
Sorry?
Is it the 11th Amendment?
No, the 11th Amendment, I think is, I'm not sure, I'd have to go look, but I think it mostly sets up an immunity for states.
Is it a 1984 action?
1983, yeah. So there's a federal statute, 47 USC section 1983, which creates a cause of action. It says if a state, and I'm just pulling it up so I have the wording, not 47. Anyone know the title number?
42.
42, that sounds right. Yeah, so every person who, under color of any statute, ordinance, regulation, blah, 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 of any state or territory or of the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured. So there is a federal statute that says if a state actor violates your constitutional rights, you can sue them for damages. There's no similar statute for the federal government. And in theory, the government has sovereign immunity and so has to create a statute for you to sue, has to agree to waive sovereign immunity. There is a case, and I was about to say this, yeah, Ben says in the chat, there are Bivens actions. Bivens is the weird exception. There's this case where the court says the Constitution implicitly creates a cause of action. It's called Bivens versus like 6 unnamed agents of the something or other. And it's something where it was sort of a Warren Court era expansion of constitutional rights doctrine that has since been whittled down and made much narrower, right? And so the court here recognizes that the constitutional claims are not blocked by 701, but it's not super clear where those constitutional claims, where the ability to pursue them comes from. It's not clear that there's any source that people can point to say, yes, you can sue under Bivens or under 1983, but for the federal government or something, right? And so my guess is this guy loses on remand anyway. But if we had some federal statute like 1983 that said, you can sue the federal government or the officer of the federal government for violating your rights, Bivens codified basically, then 701 would not apply because 701 only limits this chapter, meaning the APA review provisions. And so whatever the 1983 equivalent is would govern whether it was a judicial question or not, or a political question. So that's sort of a bit of a like side issue into federal courts land. Back to the APA, we've got another annoyed Scalia dissent. What is Scalia's problem now?
He says that like the no law to apply test falls short of explaining like the full scope of areas which the courts are excluded from.
Mm-hmm. And so what is the meaning of 701A2 according to Scalia?
This one, I'll admit, was at first kind of hard to untangle, but it seems like he's saying that A2 is referring to all law, whereas A1 is referring to just statutes, and part of all law would be common law, judicial review of agency actions, which could extend as far as like being able to still review discretion or the arbitrary and capricious or abusive discretion standards.
Yeah, this idea that 701A1 is about like Congress in a particular organic act saying no review. And 701A2 is not about those statutory constraints, but is about some background principles of common law. Like the political question doctrine, like sovereign immunity, like official immunity, like prudential limitations, all these federal court stuff. So, I mean, that's a little weird because Justice Scalia liked bright line rules, right? And so if Scalia is right, then this committed to agency discretion prong seems like it is throwing out a bunch of bright line rules in favor of this mushy, vague, traditional balancing test, right? So is Scalia like abandoning everything he believed, or does he have a good point? What do you think?
I feel like he had a good point. And in some way it is rectifiable, just because I think what his ultimate point was is that these two things need to have a weight that they can exist together. So from a statutory interpretation standpoint, just assuming A and 2 or 1 and 2 would say two different things mean the same thing, his interpretation is creating a rule where 2 means something larger than 1, so that both of them can exist at the same time, therefore unifying the statute.
Yeah, it's a good way of reconciling kind of the weird tension in this statute between A1 and A2, where they seem to mean, like, it seems like we need them to mean different things, otherwise they're redundant, but they seem to mean kind of the same thing. Or at least they mean kind of the same thing if we interpret like Block versus Community Nutrition Institute as an A1 implicit statutory preclusion type of case. And so if A1 can be about the statute and A2 can be about some broader set of principles, that's a good way of like making the statute make a little more sense. Although it seems like it's kind of inviting the courts to develop this whole federal common law of immunities under the APA, which it seems like is not really what Congress intended, right? It's not just taking this word law and from it inferring like the power to create this broad set of immunities. Adrian Vermeil, who's a professor who's clerked for Scalia, said this dissent squeezes a giant elephant through a mouse hole, because it's like taking this little word law and using it to bring in a whole bunch of doctrines that seem like they were not really what Congress was thinking about. And so it's not clear if this is something where the court was just sort of concerned about national security and therefore not willing to look at what the agency did under 701, and therefore came up with some reason to avoid it, and created some bad doctrine in the course of doing so, or if there's something that makes sense here. It's a bit of a mystery case, right? It's hard to make sense of this case. Okay, questions about that before we turn to Lincoln against Vigil? So our last case on 701 is about the Indian Children's Program. So what's the agency and the statute and so forth here?
The Department of Health and Human Services.
Mm-hmm.
And then there's the Snyder Act, and then the the Indian Healthcare Improvement Act, which a lot like lump sums of money to the Indian Health Service, which then in turn created the Indian Children's Program, which was a program they set up in New Mexico, which helped Indian children who had disabilities.
So
then
we
they-
have Health and Human Services, and within that, this sub-agency called the Indian Health Service, which gets annual appropriations to provide healthcare services to tribal populations, right? And they get this yearly lump sum appropriation. And within that program, they did this pilot children's program from 1978 to 1985. And then they closed it up and decided to reallocate the money to other projects. What did Congress know about this when they were doing all of this?
Congress didn't know anything about it because they never expressly like allocated the funds specifically for that program that the agency set up.
So it was never like, you know, a thing where Congress said you get $3.2 billion for the Indian Children's Health Program, right? Or the Indian Children's Program. They were just giving lump sum payments to the agency, which used it as it saw fit. Although they knew about it a little bit, like they got these annual updates about it, right? So if Congress never mandated this, it never provided it with specific money, it never, you know, said you have to do this program, what's the challenge?
Well, the petitioners say that they want like declaratory and injunctive relief, and they say that discontinuing the services violated federal trust responsibility to Indians, the Snyder Act, and the Improvement Act, and then the APA. And then
I mean, I want lots of money, right? And I think that the federal government's failure to give me lots of money violates their obligation to give me lots of money. But if I bring that claim, I'm going to lose, right? So what's the argument that this violated the law?
I'm looking for the exact language of this, and this might not be the part that's relevant right now, but I do remember that they had an argument that because Congress knew and was being given reports on this program, that they therefore in some way were implicitly, you know, being under the Snyder Act and all these other acts, were supposed to be giving money to them. So when that money stopped, that was a violation. But I know I'm conflating a few things there.
Yeah, I mean, like, so you mentioned, Mr. Tompkins, a moment ago, a bunch of statutes that are in play, right? Like there's, you know, and sort of different doctrines, right? There's like an Indian trust doctrine and a claim under the Snyder Act, right? And then there's like an APA claim. Just sort of at the highest level, we can sort of separate out like arguments into two buckets here. We can imagine like arguments that they violated some legal obligation that exists as a matter of law under the Snyder Act or under like Indian trust law that I know nothing about, right? That has nothing to do with administrative law, right? Like some claim that's like, you know, you violated the Indian Healthcare Act of 1958 or whatever, right? Some claim under that statute. And then separate, we have the claim that this violated the APA. And for admin, we care about that part, right? So what's the claim that this violated the APA?
Oh, okay. I got it. So basically, they're talking about the section of, I think it's 702 that provides a person suffering for like a legal wrong from a agency action is entitled to judicial review of that action.
And what's the action here?
The action, I guess, would be taking away those funds and allocating them to other areas.
Sure, the agency has done a thing here, right? They've shut down a program. And if your argument is, I am harmed by shutting down this program, you can bring a claim under the APA. Under 702, there is this presumption of reviewability. And what do you have to prove to win that?
I'm sorry, say that again.
Like, what do you have to prove as a substantive matter to win that? Like, what are the elements of that claim, right? Like, if it's a breach of contract, I have to prove that there was a contract and that it was breached and I was damaged and stuff, right? Like, what do I have to prove to win that claim for, you did an agency action that harmed me?
Don't you have to just prove the harm?
Well, I mean, like if the IRS enacts a regulation that raises my taxes, it harms me, but I still have to pay it, right?
Yeah.
Anyone? What section do I look at for this?
Is it 706? You'd have to prove that it's arbitrary and capricious or one of the other things.
Yeah, exactly. 706 is my standard here, right? Because 706 is the statute that sets forth what the court can do, when the court can order the action be set aside as unlawful. And one of those is if it's arbitrary and capricious. So the argument here would be something like discontinuing the Indian Children's Program was arbitrary and capricious, like in State Farm, right? Like in State Farm, the court said rescinding a regulation about automatic seatbelts or airbags was arbitrary and capricious because it was not an exercise of reasoned decision-making. It didn't consider the relevant factors, and it didn't make a decision that was supported by the evidence in the record. And you can make that same argument here, that like by shutting down the Indian Children's Program, when it was providing benefits to people who were using its services and putting that money into other programs that were doing other things that didn't provide those benefits, you could make the argument that it's arbitrary and capricious because, maybe they didn't consider those benefits properly, right? That would be the type of argument we have. And so in State Farm, the agency was commanded by the statute to issue rules that further traffic safety. Presumably the Indian Health Service is commanded to do stuff that provides for the healthcare needs of tribal populations. So that sounds like a source of law that the court could evaluate. So then why is this committed to agency discretion?
The court talked about how Congress only allocated a lump sum appropriation of money, which they said in appropriations law that is there's a presumption that Congress does not impose any restrictions on how to allocate those funds, and also the complicated balancing of factors for allocating lump sum payments are within the expertise of the agency.
Yeah. So it sort of points to this presumption in the law that if we have a lump sum appropriation, we will just presume that that is intended to give the agency discretion, right? That the agency can balance all of their different statutory responsibilities, all of the different populations that need services, all of the different ways they could provide services, and decide how to allocate that money across them, right? And the court says basically this is one of the traditional categories that are regarded as committed to agency discretion. And so like this paragraph on 979 to 980 talks about certain categories of decisions that courts have traditionally regarded as committed agency discretion. So a decision not to institute enforcement proceedings because it involves this complicated balancing of factors which are within its expertise. A refusal to grant reconsideration. The national security case. These are things that require balancing a bunch of factors that are particularly within the agency's expertise. And so, is this a giant loophole after State Farm? Like, couldn't the agency and State Farm just have concluded that the program where it was developing rules for car safety features like airbags and seatbelts no longer deserved money? And so didn't decide to allocate it any more money?
I don't know. I think I'm not remembering like the specifics enough about State Farm to know if this is a huge loophole to it. But it does seem like in this instance, the evidence on the other side of this, which was that there was this just kind of attenuated understanding because they were making regular reports about this limited service, that like that in and of itself was not particularly powerful. It's a very small subsection that was getting, money through a program that lasted about 6 years. And it just because Congress was aware it existed doesn't mean that it was explicitly trying to finance that program. So it seems like this particular instance is one where the other side of that equation isn't particularly powerful.
Yeah, like if Congress or if the agency in State Farm said, we've concluded that it is no longer a good use of funds for us to develop airbag rules, and therefore we are going to stop giving this unit of our agency money. Could Congress do anything about that?
Couldn't Congress just expressly say where they want the funds allocated?
Yeah, this is something that is kind of a unique circumstance when Congress is doing lump sum allocations, right? Which is not the usual case. It's when Congress is handing an agency like $700 million for the year to provide services, right? And that's not really what most agencies are doing. Most agencies have like different bureaus that are enforcing different statutes where Congress is like being more specific. This is more just a thing that applies when an agency is spending money providing services to a constituency in the public, right? So healthcare services, like social services, that kind of thing, because Congress tends to do those as lump sums and delegate implicitly the power to the agency to split up that bunch of money across its different programs. And so the best way to think about this case is State Farm and the other, Hard Look Review and cases like that about arbitrary and capricious review still apply, but there is this implicit exception where Congress just gives an agency a bunch of money to fulfill some services. And then the agency has to balance a bunch of factors like, where it gets the most bang for its buck that are uniquely within the agency's expertise and decide which programs to fund. Okay, thank you, Mr. Cox, Ms. Ezell, Mr. Hall, and Mr. Tomkunis. Any questions on this before we come back next week for agency inaction and horse protection? And Maria asks in the chat, is this why we don't have challenges to the Title IX regs? No, we have challenges to the Title IX regs. They're ongoing in court right now.
So you were saying about lump sum of money, that's when it's agency discretion, but
That is
Congress-
a category of agency discretion. Yeah.
but Congress can be like, we don't want to fund this agency. Can they do that? Or-
Yeah, sure. I mean, it is relatively rare that an agency is just eliminated because there are people who care about whatever the agency is doing who will be really annoyed if it gets eliminated. And there are relatively few people who care enough to fight on the other side. And so like, this is an area of like political economy called public choice, where it's like there is a concentrated interest group that really cares and is willing to fight and lobby for giving this agency money. And there's really nobody who cares enough to fight like against giving the agency money. So a lot of agencies just tend to like sort of stick around for a long time. Unless you have like a restructuring and reorganization that like renames them and puts them in a different department or something. But like, it's very rare that an agency is just eliminated. But, you know, it's something where like there might be budget cuts, but. Anyway, other questions? Oh, we ran over by a few minutes. I'm sorry about that. Okay, I'll see everyone next week. Have a great rest of the week and great weekend. Have a good holiday tomorrow. Thanks.